Our next case law update covers MBI Oil Gas, LLC versus Royalty Interest Partnership, LP, a case arising out of North Dakota and the 8th Circuit. This case involves a dispute over whether an oil and gas lease expired or if MBI properly extended that lease. Royalty leased to MBI in 2013. The lease's primary term was 3 years, but it included an option to extend so long as production continued on the lease premises. However, after 3 years passed, MBI did not drill any new wells. Royalty leased the same property to Oventive in 2020, and Oventive promptly drilled and produced new wells. In 2022, Royalty contacted MBI, asking MBI to release its expired lease. In response, MBI initiated suit against Royalty, claiming that MBI had properly extended the lease, which trumped the subsequent lease between Royalty and Oventive. The case hinged on the language of the lease, specifically 2 critical clauses, the Reservation Clause and the Habendum Clause. The Reservation Clause of the lease between Royalty and MBI reserved to Royalty all right, title, and interest in the Calhoun well and its production. The Habendum Clause stated that the lease could be extended so long as oil or gas of whatsoever nature or kind was produced in commercial quantities from the lease premises or on acreage pooled therewith, or drilling operations were continued. MBI argued that because the Calhoun well was on the lease premises, and since it continued to produce, MBI's lease with Royalty did not expire. Rather, MBI argued, the language of the Habendum Clause only stated that oil and gas needed to be produced on the premises, without requiring MBI to produce it themselves. In response, Royalty argued MBI could not rely on the Calhoun well's production because Royalty explicitly reserved all rights to its production. The district court held that the plain language of the lease showed an intent to exclude the Calhoun well's production from counting toward MBI's production, thus causing MBI's lease to terminate. MBI appealed. The 8th Circuit acknowledged that while MBI's argument regarding the Habendum Clause would typically hold true, the Reservation Clause, which preceded the Habendum Clause, expressly reserved the Calhoun well's production to Royalty, as the Reservation Clause's language of all right, title, and interest was express and unambiguous. MBI could not claim the Calhoun well's production, as that would be tantamount to declaring that MBI had some type of interest in the Calhoun well. Overall, the 8th Circuit upheld the district court's ruling that MBI's lease had expired and that Royalty and Oventive's lease was proper. So what does this mean? Leases are pretty valuable, but drilling wells is expensive. Lessors will go to great lengths to argue that their lease is still valid. Just recently, we saw the Texas Supreme Court rule on the continued validity of a lease in the Cromwell versus Anadarko case, and go the other way under a different set of facts, holding that the lease was valid without drilling. To hear more about that case, listen to episode 8 of our podcast. That's all for today. I'd like to thank Frances Warden, a law clerk in our Denver office, for her help on this episode.